I had a client who slipped and fell on ice in a parking lot, broke his arm pretty badly, and because it's a slip and fall, unfortunately there's no access to accident benefits. So all that was available is either a tort settlement or a tort judgment. That's sort of it. So we were, in negotiations with the insurance company. The property was a private parking lot. It was around the time of a snowstorm, and that was the insurance company's big argument. The client went out during a snowstorm. It was kind of their fault. They shouldn't have done that. But we requested all the records of the maintenance company that was handling that area. I think it was a January or a February or something like that of winter time, and we found that they didn't salt the grounds for about 9 days before the incident. The person, this happened early in the morning, and they came out to salt later in the day. And they knew that the stores were open at the time, much earlier than they actually salted. So it wasn't really relevant that a snowstorm happened because there would have been ice before that even happened anyway, because they didn't bother with taking care of the parking lot. Another argument the insurance company had was that he returned to work. And some of the time they took off work, he got long-term disability, so it didn't really affect his bottom line in his career. But we argued that it actually did, because really he wouldn't be the same employee that he would have been had the injuries not happened. We had an expert testify and read a report about his arm, about how it would never fully heal and it affected his daily life. The defense had their own orthopedic surgeon testify and read a report, and that actually helped us out a lot because, found that our client was very credible. He didn't talk of his injuries more than usual. He just was in a lot of pain, and it was frustrating because, because it's his arm, he's able to walk around, he can use one of his arms perfectly fine. So, the insurance company kept saying, he's okay. But because of those two reports, we were able to get what I think is a very fair settlement for the client. We were able to get him pain and suffering, which is not subject to a deductible because it's a slip and fall. We got future care, which was bolstered by the fact that we got these reports by both our orthopedic surgeon and the defendant's orthopedic surgeon. And we got what's called loss of competitive advantage, which, like I said, he's not going to be the same employee that he once was, so they have to compensate our client for that, even though you can't exactly see it in his salary. When a slip and fall happens because of ice on government property and municipal property, you have 10 days to let the municipality know. Not a lot of people know that, but it can be very, very frustrating. If you wait maybe a year and then tell a lawyer, might be done, unfortunately. I think new provisions have come in for private property for ice, which gives you 60 days, which is still not a very huge amount of time, especially when it comes to concussions. And another thing as well is that when it comes to slip and falls for ice on municipal property, you have to prove what's called gross negligence. And it's a bit of a meaningless phrase, unfortunately, but it just means that the bar is a lot higher that you have to prove. And sometimes it can be very, very difficult to show that a municipality was grossly negligent because, that's their job. Their job is just to fix roads and salt the snow and the ice and sidewalks. But you don't need to prove that for private property. So sometimes, unfortunately, the same exact accident can happen, but a very different outcome can come out depending on where that person fell.